Oops, look who came in first today.
There we go. Well, that might be the last time I'd ever come in first.
And why would that be?
Well, we got this world-ending solar eclipse coming up on Monday.
Oh, dang it, I forgot. You got to be first and we're all going to die on Monday.
Yeah, I was just making all my preparations, getting all my survival stuff.
Well, now I want a do-over. Now I want to have to do it over so I get to come in first.
Well, I guess we'll see if we're still here Wednesday, I guess.
Yeah.
Bring yourself in on Wednesday.
Oh, that's true. That's what I'll do then. You know, if we
make it.
If we do. Okay, well, our guest is having a little bit of trouble getting on this morning, so we're going to do what we normally do, which is tap dance until then. So what's up with you today, Michael? You said you had some things.
Yeah.
What things do we have?
Well, just kind of depends. Did you get a chance to read the election article from government
Oh,
task force?
no, but thank you for bringing that up. I mean, you're right. They did release a document from the, oh, what did they call it?
I'll have to
Task
look.
Force, Oklahoma Election
Task force.
Task Force. Yes, they did release the document. I have not had a chance to read it yet. I shall do that. And then maybe on Wednesday, we can talk about that for a
Yeah.
minute. Did you read it?
Yeah, I went through it pretty. It's not real long. It's pretty quick.
So what, give me your throwdown on that.
Well, I mean, I hope it's gonna be good. I think there might have been a link in there to like a further explanation. I think that was just like a summary deal.
Okay.
And then I think there was a link to, and I didn't read the second part.
Did they even say where their meetings were or when they had met, or?
I don't think so. It was pretty general. It was more just like an announcement. Hey, we're going to make this task force. We're going to look at this and this and this. And
Well, the task force had already met. The document I saw said the task force had already met.
Yeah. Well, yeah, correct.
So, well, over the weekend, hopefully and then for those who actually subscribe to the email, I'll stick it in the newsletter over the weekend so other people can read it too. You got anything else for me?
Well, I was just going to get your thoughts on this solar stuff.
On the eclipse?
Since you're a biologist.
Yeah.
I mean, that would qualify you to, I mean, you're a scientist.
Oh, yes, that's for sure. A scientist, especially a biologist, knows about everything, including astronomy. So,
no, it's funny to me how wild people get in. It reminds me of the Y2K stuff. Do you remember how crazy everybody went in Y2K?
100%.
I remember
100%.
I was in college. Literally, I was in college, and this was back before they really had all the security on the computers and stuff. I was going in. I was changing the date. I was in the computer lab. I was changing the date on all the computers, to be in 2000.
Right.
Just to see what it's going to do is funny.
Well, I look at things like this. Jesus actually gave us the parable of the bridegroom. And so I think if you follow the parallel, or if you follow the parable of the bridegroom, you'll realize that basically he said, no idea when the bridegroom's going to show up for the wedding. So, hey, ladies, better keep that lamp lit. But I think it wasn't just for ladies, of course. I think he meant it was for everybody. So yeah. I think so long as we're doing what we're supposed to be doing every day, it shouldn't really matter what happens outside of that, right?
Correct.
I mean, that's at least my theory on the topic. So whatever happens on Monday happens on Monday, and whatever, good night. I'm going to run to Costco today. So I might buy it on the turnpike. I mean, we never know.
Yeah.
We simply never know.
So either way, you may not be here Wednesday. Natural phenomenon, some type of accident, whatever. Solar eclipse.
This is actual factual. It just could be
some kind of portal. Portal opens up and you fall through it, like my wife's biggest fear, sinkhole. Might be driving and just fall into a sinkhole.
Stop, poor Lauren. Stop.
Yeah.
Yeah. I mean, honestly, it's kind of like the bridge. I mean, I kind of look at it the same way. Falling into a sinkhole, falling down a bridge. I mean, it's like I don't know. I don't want to be in any of those positions, frankly.
Yeah.
I'd prefer not to.
Yeah. Well, I will tell you, we've done multiple open records requests. I've had some other ones with some other people. I didn't really share it in the group. I was doing some for a couple other parents, and then we have ours that we are, and I still have not heard back from anybody on anything. I mean, it's like literal, you send in these open records requests and they know that there's no time constraint on that unless you just literally hound them every single day.
Well, but there is a
they
time
just ignore you.
constraint.
No, there's not a time constraint.
There is not.
Oh.
I thought they had to do it within a certain number of days. That's not true.
No, if you read the statute, which we had on the website, and they reformatted
Right.
that, so now it's hard to read. The first time we had that link on the website, it's real easy to read the whole statute, but it basically says they should be filled in a timely manner, but there is no time frame. I mean, they could take 10 years if they wanted to.
Well,
that's what they do sometimes. I mean, ultimately they may get around to it years later. And that's the no teeth part of a lot of this legislation that we have.
Uh-oh, hang on a second. Beth Anne says she's on, but I don't see her in the waiting room.
I wonder if did you send her the right link?
I hope I sent her the right link. I'm pretty sure I sent her the right link. Okay, well, hold on just a second. Let's see. Hang on. Let me try this.
Well, there's only one link in the dashboard.
Yeah, I know. That's the thing. Oh. Okay, so yes, I'm going to have to send her. She got the wrong link and it sent her to another meeting that wasn't ours. So this is what happens on live podcast. Da-da-da-da. Okay,
well,
so
I think that's kind of the whole magic of live.
Isn't it? And people get to go, oh, look what happened to them. Isn't that hysterical? Which is obviously like super not funny, but oh well. There we go. Okay, I think I finally did this. Let's see. All right, so hopefully that will solve that problem. Let's see. But in the meantime, hopefully, while we're waiting on Beth Anne to get on here, remember we had Whitney Mullica of Pike Off OTA. Come on. And she was actually going to come on today because Pike Off OTA, or Citizens for Responsible Transportation, I think that's what we're supposed to call it now. Citizens for Responsible Transportation had worked. There's Beth Anne. Okay, hold on. Let me get you on here. Okay. Hang on. There's Beth Anne. How are you?
Fine. I am so sorry. I started working on this about 45 minutes ago. Didn't go. So anyway, I downloaded Opera and then Opera crashed. So anyway.
Well, we were just talking about the fact that live podcast is just phenomenal because they get to see behind the curtain. Whatever happens. And we're all like, okay.
Behind the curtain.
So let me introduce you. So as I think numbers of you know that I was mayor in Luther for 4 years. And when I first started, we had an attorney and we did not keep that attorney. And we were subsequently introduced to Beth Anne Childs, who subsequently became our town attorney, and she is still the Luther town attorney to this day. And Beth Anne, you've been in practice for what, 28 years?
30 years.
30 years, holy cow. And but now, have you always been in town? Is that always what you've done, is be an attorney for towns?
For a short period of time throughout my career, I was in private practice in Oklahoma City for a little over a year. And then after I had kids for about 18 months, I did medical malpractice defense.
Oh, wow. Okay.
Other than that, the remainder of my career has been working for cities and towns.
Okay. So I would say that if we were going to have anybody on to talk about open meetings, it would probably be you.
I don't know about that, but I'll try. I've sat through a lot of public meetings.
Well, let me ask you this question to start off. I was under the impression, I think, Michael, I don't remember. Did somebody tell us that the Open Meetings Act had changed just recently? Are you aware of any changes to the Open Meetings Act?
Mm-mm.
No?
No, I don't remember. Unless someone told you, they didn't tell us.
Beth Anne, do you know of any?
I don't. I know that every year the legislature tends to make tweaks to it. As a general rule, though, I don't look at it until after sine die, or
Yeah,
people
right.
pronounce that different ways. But with the Oklahoma Municipal League, they will send out the sine die, and it's after the legislature adjourns, and then I always go back and look and see. But what I can tell you is every single year, the legislature does something to the Open Meeting Act.
Now, in your opinion, has that occluded transparency or helped make transparency better?
I think it depends. I think that the goal is always to increase transparency, but sometimes the practical implications of it may not, for a variety of reasons. A great example would be during COVID.
Okay.
Because I mean, that's the
Yes.
perfect example. And, if you like, I'll just give you a super quick example.
Oh, yes, please.
I was hired by OMAG to represent the town of,
what is OMAG? Tell people what OMAG is.
it's the Oklahoma Municipal Assurance Group.
Okay.
And the town of Big Cabin, and this was very shortly after the governor had basically closed everything down. I'm not going to use the proper vernacular.
Sure.
But the town of Big Cabin, like every other small municipality in the state of Oklahoma, was really, really struggling with how to conduct business yet remain transparent.
Right.
And so what they did was they didn't have the technology, and most towns at this point in time didn't have the technology available to do the online meetings to where people could meet. So they had a meeting, but they restricted the number of people that could come in. And from the perspective of those elected officials, I mean, they thought that they were following the governor's order. They were trying to control the spread. It was very early on in the process. No one was really wearing masks, and they actually got sued over that. And so, on the one hand, the people that wanted to come in, and there weren't that many, but they were like, okay, well, this decreased transparency. But the motives and objectives of the elected officials really were pure. I mean, they were just trying to follow the mandates of the governor and ensure that people, were safe. So that's just one example. I represent the town of Winona. It's a very, very small community. And the cities and towns, we still had to carry on business, as you remember, during COVID. I mean, you still have to provide police protection and water and sanitary sewer service and all those essential functions. So the Board of Trustees in Winona, we actually sat outside. So, you saw a lot of people, but, I think a big hurdle to all of that was the lack of technology, which I think that the federal government and the state government, for that matter, has worked really diligently to help.
So let me ask you a couple of specific questions. We were talking about open records requests before you came on. We have a number of people who write us frequently and say, we'd like to have so-and-so school board or, whatever, mainly school boards, provide me information about this. And as Michael and I were just talking before you came on, Michael, how many do we have outstanding, Michael?
Oh, there's probably at least 5 or 10 that have not been answered.
So how old
or maybe even year? I mean, I've got some that are, goes all the way back to the start of COVID that are still open that they've never provided data for.
So how do you navigate these waters when, according to open records, it's just kind of in a timely fashion is the idea, but then we have people that we submit open records to that just, keep rolling that ball down the road and never, submitting the requests. I mean, do you have how can we give us some insight here?
Sure. I will say this, of course, I represent public bodies,
Right.
and I can tell you that sometimes the sheer number of the requests and the volume can be debilitating. And so you can't even get on with the business of the governmental body, whatever that is, because you're having to work so diligently to respond to this request. And the advent and advancement of technology has made it a million times worse. And so, hold on one second.
Sure.
Hey, can you unplug that dinglingy thing?
The dingling, whatever that is.
Technological phrase, but it
A technological phrase.
yeah.
Sounds like something we need to trademark.
Yeah, exactly. The dinglingy thing. So hopefully that will stop that annoying noise on the side. But so I guess my tips to you would be as follows. I mean, recognize that for the most part, most of the people that work in government that I have come into contact with, okay, certainly, and I'm talking for the most part, municipalities, although I do have a lot of friends who represent school boards. I do think for the most part, they really appreciate the sunshine laws and the importance of the sun shining in on everything government does. I think that they recognize that it's public money, it's public time, and that people have a right to know. But when you get these gigantic requests, like I want every email between the chairman and the vice chairman between 2010 and 2024, I mean, things like that. I mean, that's almost an impossible way. Now, a lot of times I think that school boards and municipalities in particular have gotten a lot better about putting contracts and providing access to contracts, minutes, agendas. Most of those things should be available on their website. For the smaller municipalities or the smaller school districts, maybe not. But I mean, like in Winona, population 452, yeah. I mean, we have a Facebook page, but it's hard to get that done. But if you will, narrow the request as much as you can to really get the information that you want, I think that helps substantially. A lot of these individuals have, or a lot of the districts have search engines for their emails, and that helps a lot. So if you can, really tell them, okay, what you're looking for, then typically, and make it narrow enough to where it's, not overly broad. I think that helps too. Most of the school districts are represented by 2 law firms, I believe, in the state of Oklahoma.
Yes, you're correct.
Yeah. And they're both very, very good. I mean, in my opinion, I mean, they have very, very good lawyers, and I do think that they work diligently to balance, because it is a balancing act. You know, you have to balance between application of the act, providing transparency versus personnel interests, and all of those sorts of things. So, you know, and of course, the statute provides that you have the ability to bring suit. So if it hasn't been accomplished after, you know, meeting those benchmarks and objectives, then I think, you know, you may want to consider bringing an action. And that's the purpose of that in the act.
Yeah. Let me add a couple caveats in there.
Sure.
I've found in my time of doing open records requests, almost all municipalities or any state organization or even federal, they seem to be very, you know, responsive and actually get the data back out, you know, within, you know, a month or 2 months or something. But when it comes to school boards or school districts, I mean, it's like pulling teeth. They put in all these, they make you almost enter into a contract with them with exorbitant fees and all kind. I mean, they block you at every possible avenue, you know, you can get blocked at. But as far as like municipalities and all the other agencies there, I've never had any issue getting data there. It's just specifically school districts.
Well, and I think that the problem that we have with school districts is not something that, you know, and I do think this is one good thing about having you on, because you actually are sitting in a completely different spot with a different perspective. And I think having that conversation, because with us, our perspective is that school districts particularly are not transparent at all. And they block us at every point. And you know, we have a friend who is with Oklahomans for Responsible Transportation, who has been the organization that's been suing the OTA for particularly basically that same thing. And you know, their opinion is kind of the same thing about the OTA. So it's really interesting to have you on so that we're able to hear a different perspective about that. Because I know that when I was working with you, I felt like that we were as transparent as we could possibly be. Now, the one thing that always did upset me was executive sessions, you know, and I think there are some things, particularly there's a thing that's just come to light recently over an executive session that we had when I was mayor, that I was like, oh, I wish that there was more transparency there. Can you kind of, and let's talk about that specifically, because I know there are a lot of people that have a problem with school boards. And here's what ends up happening. They'll do a certain amount of business in front of the public, and they'll have an agenda, and the agenda will be published, and they'll do that agenda. And then at the end of it, they'll go into executive session. They never even come back. You know, they just leave after they've finished with executive session. So you never even seem to get them back in the room, which doesn't seem right, because I know that when I was mayor and we had an executive session, we always had to come back in and say what it was that we did as much as we could while we were in executive session. So how do we know as citizens that a body is following all those laws with executive session and being transparent? I mean, because it's a real sticky issue.
It is. You know, as you remember from our time together, I mean, I am very much a stickler when it comes to following the statutory requirements of executive session.
Right.
I mean, if you look at the state statute, and, you know, like I was telling you, this book right here, I take it with me to every single meeting, and it's put out by the Press Association. It really is an excellent publication. But every time I have an executive session, I review the statute to make sure the subject matter complies with the statute. I draft the agenda language to make sure that it applies with the statute. You know, a lot of times people want to have executive sessions, like, for example, over like a business or bringing a recruiting
Yes.
business to town and, things like that. And you just have to be super careful to make sure that they're following. So I guess my first word of advice would be that if you are following a particular public body, review the agenda. Look at the agenda, make sure it references the appropriate section of the Open Meeting Act and regarding executive session. Look at the language. Make sure that the agenda properly identifies what they're trying to do. Now, this is the balance. It's kind of interesting. It's something that I always think about, but like it's a little bit different because I have sympathy for public employees because it's a little bit different than like if you worked for, I don't know, Google, for example. So if you make a mistake working for Google and, you get called in and they discuss that with you, I mean, no one is going to know about it. The whole purpose is no one is perfect. Everybody makes mistakes. It's just such a good way to, you can cover it like that. Well, if you're an employee of a public body and you're employed by the board of trustees, I mean, everybody in town, if not the United States of America, can know that you're being brought into executive session to talk about your employment, your performance, your whatever.
I'm very well aware of that.
Jenny is the object of the executive session.
Sorry.
It's okay.
I mean, I do think that matters. I think that there should be a mechanism by which you're able to discuss your employees without the whole world knowing. And that's why, the legislature was so thoughtful in crafting that particular section. Something else is litigation. I still do some litigation, and my clients, the board of trustees or the city council members, they ought to be able to discuss the pros and cons of that litigation in executive session, because they wouldn't be able to properly evaluate litigation either for or against if they didn't have that opportunity. So those are my tips for doing that. And, I know all bodies do it a little bit differently with regard to executive session. And I'm not going to render an opinion about who does what, but, any formal action taken by the board or the council or whatever is supposed to be made in executive session. I mean, it's supposed to be made out of executive session.
Right.
So like, for example, if we talk about pending litigation, and let's say there's a settlement amount and you're going to mediation. Now, you probably don't want to come out and have somebody make a motion to say, move to give the city attorney $35,000 worth of authority for mediation. Okay, that would be crazy, because then when you go to mediation, the other side's just going to look at you and go, well, you have $35,000 authority. We want you to give us $35,000. I mean, That's not a good use of taxpayer dollars. So typically, I'll recommend, but the boards or the body still has to take some action. So typically what I will do is recommend that they say move to, move forward with settlement and pursuant to the direction given by council. But I mean, that's kind of a silly example, but I mean,
it's a good example, actually.
100,000 if, you can settle it for 20.
Well, let me ask you, like your opinion on maybe the openness of, and also the leeway that's given in executive session for some of these topics. So let's take, like, for example, Edmond Public Schools has a special meeting. They published the agenda, let's say, as like a couple months ago. And this is in relation to them suing the State Department of Education for the library books, for them to be able to use the library books, keep them in the classrooms or wherever. Well, what happened is that special meeting, they called that special meeting. We all read the agenda. The agenda said nothing about them possibly thinking about a lawsuit with the library books, had nothing to do with that. They do their one or two items in their special meeting. They go into executive session. Then all of a sudden they come out, and the next day they're suing the SDE on the library books. I mean, I feel like as a parent, as a taxpayer, I should at least know the subject of the executive session. You know, they're actually going into that executive session to make the decision to sue the State Department of Education. But we as parents, like we had no idea in any way that was going to happen. And then when we contacted like the school, they said, well, you're given special leeway. You know, if you get into topics like that in the executive session, it doesn't have to be disclosed to the public. Like, how would you feel about, I mean, is that how it works? That just seems like a transparency, like a non-accountability issue. They can know they're going to go into executive session knowing they're going to talk about something that's very controversial to the public, and the public has no idea.
Well, I mean, I'm not going to render a legal opinion about the Edmonds School District. I mean, because the one thing I will say is we all do it a little bit differently. And while it may seem some of the stuff may seem to be super simple, but there are so many nuances. And granted, you can get through the Open Meeting Act in 20 minutes. And you wouldn't think that there would be so many nuances associated with it. But I mean, there really are. I mean, there are many times when, if I have a question about it, I'll call one of my colleagues and say, hey, have you dealt with this issue? How would you go about handling it? But I mean, just going back to the basic purpose, which is the whole purpose of the act is to provide transparency.
So if a body does not, are you with us, Beth Anne? Uh-oh, Beth Anne has frozen. Hopefully she'll come back to us. I do love her necklace. It's very, very nice there. Well, hopefully she'll come back. And when she comes back, we can pick up where we left off, because I think that was a really good question. And
it's just, I don't like the fact of, they know ahead of time what they're going to do. That's why they called that special meeting. They knew that the event of that special meeting was to vote on going into go to sue the school board. But they didn't tell, if they would have published that there's a they're going to discuss in executive session, they're going to discuss suing the school board, the SDE over the library books, you would have had a throng or plethora or just a mass amount of parents there at that executive session.
Right.
And because they didn't say anything about that, it was just all these other little things that they were having a special meeting for. And then they go in there and it turns all the way around to suing the SDE. I mean, I just think that's kind of going around the Open Meetings Act, in my opinion.
Oh, there she is.
Right.
Okay. Like I said, we deal with this kind of stuff a lot. It's a live podcast. We're okay with that.
Yeah.
So we were just making the point while you were absent that because I understand where you're coming from. I mean, you're an attorney and you have a specific thing that you do. And I get that. But I think Michael's point was that if they don't put something on the meeting agenda, and yet they come back later after the meeting and say they've done something, and I'm not even, I'm just talking in general, anybody comes back and says something that they're going to do something, which means that they've made a decision about it, because you can't just go, oh, the superintendent's just going to go, oh, I'm going off on my own and do, blah, or the CEO or whatever. Anyway, how do you address that? Because I know one of the things that was so frustrating for me before I became mayor was when I would try to talk to the town attorney about things, and I would say, but wait a minute, out here, the perspective is here from the citizens, the perspective is this, and that there's not any transparency. And our previous attorney would say constantly to those of us who were the citizens, well, I don't represent you, I represent the town. And that's the truth. I mean, you represent the town. You don't represent its citizens. You represent the town. You're trying to make the town do the right thing. You're trying to make the town follow the law, that kind of thing. But at some point, the citizens, we have, and I know that when I was mayor and you were our town attorney, I was constantly concerned that the citizens had their rights, that they were able to speak, that they, that we were listening to them, that we didn't do things in secret, all that kind of stuff. But when you have a situation in which something is not on an agenda, and yet something else happens. I mean, is there not any redress from the citizens? I mean, is there no way to redress that situation? Because obviously that's not correct.
Yeah. And I mean, I'm going to go back to my book. There is actually, I mean, I tell you what, the Press Association, I mean, I order this book every single year.
Yeah.
And I read it usually once a year, cover to cover, just to refresh my recollection about what it is. But the beautiful thing about this book is it really does provide very good guidance. And it talks about, I mean, there are some cases, obviously, that have been decided by the Court of Appeals and the Supreme Court that have to do with things that weren't specifically on the agenda. And so I would encourage you, if you really want to, pursue things that are happening with regard to things that aren't on the agenda, get one of these books, look at the case law. And, I'm always a fan and an advocate of going to the district and then to the district's attorneys first and trying to get something worked out with them and say, look, I have reviewed this book or this case or this, and this is what this says. And this is why I'm concerned about what happened. And then, of course, at the end of the day, if that is unsuccessful, you always have the ability to file a lawsuit against the public body.
Yes. And there's a frustration for us there because then the citizens are the ones, because Michael is actually did bring in action against the Edmond Public Schools and he did win. And Michael, how much did you guys spend on that lawsuit?
$52,000.
Yeah, it's an expensive venture. You theoretically, though, if you prevail, you should get costs and attorney's fees back, right?
And they did, but
no, there was no damages in the case. It was.
Oh, I thought you did.
No, we would have to sue for those separately, but that's a whole nother issue.
And that's the other point, because citizens are already paying taxes, and those taxes go to pay for the attorney for the school or for the town. So the citizens are already paying taxes that pay those attorneys. And then we have to go and raise $52,000 to fight the attorneys that are already getting paid with our tax dollars.
Yeah, I understand. I mean, I hate to keep, pounding on that, the balancing act. I mean, because my ethical responsibility is, of course, to the cities and towns that I represent, my elected officials. That's my job and my responsibility. Yes, I am paid with tax dollars, but I'm kind of a cheap date compared to most lawyers.
You are. I can attest to that.
Yeah, I'm kind of a cheap date, but they have to follow their ethical obligations. And so one other thing that I will say is that there are a number of mechanisms in state statute which give people the ability, and I understand the initial financial outlay, but there are what are called qui tam statutes, and that I think that they're
statutes.
Qui tam, Q-U-I-T-A-M.
Okay.
And I think they're in Title 62. I dealt with a couple of these when I was in Broken Arrow.
Okay.
But it's basically where someone can bring a lawsuit in the name of the king or on behalf of the public. Now, that is mainly going to be pertaining to like a contract, to an illegal contract.
Okay.
So if the city or town enters into an illegal contract, or the school district, then you have to file a demand with that entity and request that the contract be terminated, and explain why. Maybe it was a violation of the Open Meeting Act. Maybe you didn't have sufficient funds appropriated for that purpose, all the things like that. And if the district or the public body declines to take action, then you would have the ability to bring a qui tam action, and usually it's going to be like whoever XREL state of Oklahoma against whatever body. So,
well, actually, that's super helpful, because I think I had heard about that long time ago, but I hadn't thought about that. So, yeah, I think we're going to look that up, aren't we, Michael?
Yeah, for sure.
And see what we can do about that. So I've got another point that I wanted to talk to you about. Another of the problems that we've been having are things that we dealt with when I was mayor, and it's the same thing with school board. So towns and cities, schools, same thing. When I was mayor, we had a couple of instances, where we had to take employee actions, and school boards take employee actions. The thing that frustrated me the most, and I'm hoping you can help me through, is and I think I voiced this numerous times actually, it frustrated me that in some cases, well, in all cases, we were not able to tell the public why somebody was either being allowed to resign or being let go. And we were advised numerous times that if somebody called, that we were not allowed to say what that was. In that particular instance, what it's allowed to do in cities and towns and in school districts is allow people who perpetrate bad actions to be employed by other groups, other cities and towns, other school districts. We've seen this particularly with school personnel who have taken liberties with children that they should not have done. And they don't seem to be brought to justice, and they seem to just get moved from one place to another, which provides no protection for the citizenry either way. Do you see any way? I mean, is this just state law that prevents this? I mean, why are we in this situation, and is there any way to get out?
Well, I mean, I am not a traditional employment attorney,
Right.
although, a lot of what I do is employment.
Right.
I'd like to first go back to the fact that, if you work for Google or Amazon or whatever, your termination or your resignation is not something that's going to be broadcast across the state.
No, but you're not paid with tax dollars either, though. At Google.
No, I understand, but kind of you are, because if, let's make it Amazon, because if you're a municipality, you make purchases through Amazon. I mean, there are tax dollars going for that. So I know that's kind of an extreme example, but, the same argument could be made like with regard to, the Catholic Church, for example. I'm a bad Catholic and a good Lutheran. And, the bad Catholic part of me is always concerned about, the sexual abuse allegations that, were rampant in the church. But I think that the employment attorneys are always going to require caution when it comes to releasing information that's not addressed specifically by the act. I think that sometimes the thought process behind allowing somebody to resign as opposed to firing them is that if you fire them, a lot of times, if somebody's under investigation, for example, in a city or town, and they resign, that can result in a huge savings for the municipality in terms of time and finances, because a lot of times what they'll do is then they'll file for unemployment, then they may file a complaint with the EOC, then they may, go through. And so the city or town might end up spending $10, $20, $30, $40, $50,000 fighting a termination that was justified. So I think the school of thought has always been, okay, it's better just have them resign. That way they can move on down. But this is the thing, though, is if someone is performing an act that is a crime, And this is important. If they're doing something that's a crime, you have an obligation to do something about that. And let's talk a little bit about child predators, child sexual abuse, those sorts of things. I mean, we're mandatory reporters. I mean, if you're at a school district, I mean, you're a mandatory reporter. If you're employed by a city or town and, you work with, youth sports or whatever, you say the same thing, mandatory reporter. The flip side of that is that, there are people that are wrongly accused of things. And so I think that is sort of the balance to that. But, embezzlement, financial crimes, those should never go ignored by public bodies. Every single time you should have a police report. They should be reported to the DA's office or the FBI. And, so I guess what I'm saying is that there's a difference between somebody being let go because they're not really doing their job and, they're sleeping or playing solitaire on the computer,
right,
versus committing a crime.
Right.
And, we all have the obligation to ensure that the people that are committing crimes, that goes through the proper channels. Does that make sense?
Yes. Yes, I still think, there's, and I do understand there's a tension there. I mean, I've been accused inappropriately and wrongly and let go. But then again, I'm going to have to do something about that on my own dime. It's hard to explain because we don't want people out in the public who are going to harm others. And when people just refuse to do, and these are when taxpayer people who are paid by tax dollars refuse to do their duties, then, that happens, and it is happening and has happened. And I think we're just trying to muddle through that and figure out how we can navigate that to keep people safe. But on the other hand, put these people away so that they can't do this to other people.
And I think that's really an educational component. I mean, frankly, you look around, the Tulsa metropolitan area. I mean, I think that there was an issue several years ago involving the Bixby school district. And, I always remind my clients, we're mandatory reporters. We have an obligation to contact the police or child welfare or whoever, and you want to document that. But I do think there are some opportunities to educate our elected and appointed officials about what their responsibilities are. Because I do think that there's a difference between, good grief.
I know. I was going to say, wow, you're on a motorcycle race.
I know. It's been that kind of day. Sorry. Difference between someone that's committed an illegal act and somebody that's, maybe not performing their job the way they should be.
Yeah. Okay. One other question, and then we're probably done for today since we're almost at an hour. It goes very fast, doesn't it? There is actually a bill in the legislature right now, HB 2730, that would amend the Open Records Act to put in a specified time limit for providing open records requests like we were talking about today. Do you feel like as a town attorney, as somebody who's, paid to be on that side, do you feel like that's a good thing or a bad thing?
I have significant reservations about it, only from an operational standpoint, because, I'm going to go back to my town of Winona, population 452. Okay. I mean, we have basically 5 or 6 employees. And so every single time they are having to research to provide information, it's taking away from their ability to process utility bills, read the meters, deal with sanitary sewer breaks, deal with water line breaks, coordinate water, respond to police calls, all those sorts of things. I you definitely want it to be within a reasonable time. And I realize that they wonder, okay, what is a reasonable period of time? And I think that, the old lawyer response is, it depends. I mean, if it's a copy of a contract that they approved last week, well, that should probably take about 10 minutes, but that would be a reasonable period of time. But if it's text messages between the mayor and some guy down the road that were exchanged 10 years ago, I mean, that's going to be a little different. So
so do you think maybe like a sliding, because I actually can see that. I mean, that does, when you say that, it makes complete sense. If I'm asking you for something that happened last week, you better be able to pop that right off.
Right.
But if I'm asking you for emails between school board members from 3 years ago, that's going to be a lot harder of a challenge.
Yeah.
So I wonder if maybe that has to be part of the rule, is for, maybe there's a sliding scale. Maybe, for immediate things that have happened immediately, you get them immediately. I mean, you have 10 days, but after that.
And volume matters too. I mean, I've put together some information on different, open records requests where you had like 17,000 emails.
Yeah.
And you can't just turn over a flash drive. I mean, you got to make sure that there's not, does it have confidential personnel information? Because then you expose your client to liability if, there was something like that in there. And then, maybe involving a claim or litigation or something like that. So it is challenging, balancing the public's right to know with what aren't you going to get done today because you had to read 17,000 emails.
Well, and it's interesting that you even say that, because I was actually in court yesterday as a viewer watching a case, and the case that came before the one I was there for was talking about Epic schools, actually. And so it was records that they were going through. And, the one attorney says, well, now we have AI. So that really helps us get records, because they just type in, they use an AI program and then type that in, and then the AI goes out and searches the records. But of course, you're not going to have that in a municipality of 400 people, or a school district where there are, 400 kids. But she said that because they were asking for, the other side was asking for a very long number of years, and the documents were like 55,000 documents. And so I can totally see at that. And those were documents that had to be redacted. You had to redact them to make sure that there wasn't student information in there. There wasn't, confidential contract information in there, that kind of stuff. So I do think that having you on this morning has been really great, because it gives us that exposure to the other side. Because I think there's a situation, I think you even might agree with me, where people are just super frustrated today. They don't feel like government's working for them anymore. They don't feel like government has their best interest in mind. And it's just always hair on fire, right?
Yeah.
And I think it's important that we hear the other side, because I think what I'm hearing, and Michael, check me up on this, I think what I'm hearing from you today is there are rules. We need to follow the rules. Everybody needs to follow the rules. But when we want information on the opposite side, when we on the opposite side want information, we need to be very careful about the information that we're asking for.
Narrow the scope, be professional, be respectful. I mean, all of those things I should, help in terms of, because I've got plenty of friends that, are plaintiffs lawyers or whatever. And, most of us are very, very collegial, and, just because we may not agree on one particular thing, but we still treat each other, professionally and respectfully. I think that from my perspective, one of the things that we are seeing that is not great. There are two other things I'd like to offer perspective on.
Yeah.
The first one is what we kind of refer to as weaponization of the Open Records Act. And I mean, I can give you several examples of where you've got private citizens that basically decide they don't like a public official, be it elected or appointed. And so they just go crazy with open records requests. And, everybody gets to make a mistake. It just, we don't do anything in a vacuum. And so they just produce these mass requests trying to catch them in making a small mistake.
Yeah, I see.
Right? And that, I mean, it's a huge disruption. And also, it is hard to find people that are willing to work for governmental entities. I know that that's probably not a popular topic, but I mean, we do a lot of unpopular things. Animal control, working on the sanitary sewer system, working on the water system when it's freezing cold outside, working on the electrical lines. I mean, it is difficult, especially in this day and age where in Oklahoma, I mean, you can make a lot more money working for a private entity.
Yeah.
And so like in law enforcement, you see this constant cycle of people leaving municipal government, not just for pay, but, because everything they do is open to the public. And it just, I mean, it's tough. It's tough to recruit and retain good people to do the jobs that a lot of people don't want to do.
Well, I mean, and that's a good point, because I remember when I was mayor, we're not paid for that job.
Yeah.
Going to meetings, have people come and, scream and yell at you because you're going to have to raise the water rates or, that kind of thing. So I get it. It's not, I mean, you have to be you have to not mind controversy at all. I mean,
Right.
You just have to be able to withstand controversy. And if you can't do that, then, being an elected official, isn't for you, or an appointed official. But again, like we've talked about throughout this whole podcast, balancing is important, just like we have to make sure that, our public officials aren't exposed to, ridiculous things and accusations and that kind of stuff. We also have to make sure that the people who are paying their salaries are also being treated fairly and appropriately.
Certainly.
One thing, because I know we're in an hour, but I'm just dying to know, this is just take your, town hat off and just be an attorney for a second, because I'm dying. Part of what happened in this case yesterday made me pretty agitated. And that was, the Constitution of Oklahoma addresses this issue specifically, but case law has adjudicated away from the Constitution. And now we're following case law, which is adjudicated away from what the Constitution says. And now we're over here. In your opinion, as an attorney, what is your thought about case law versus the Constitution, the Oklahoma Constitution, any Constitution?
Well, and of course, I really haven't followed the case that you're talking about. So I don't.
I'm just talking in general. This is just a general statement.
In my experience, most of the cases that I have handled, that the case law follows the Constitution.
Okay.
It just interprets it. Now, I mean, the interpretation may not be what, because, it's amazing to me how you can take one provision and get 75 different opinions on how it's supposed to be interpreted. I mean, that's why the law is a living, breathing thing and makes it so amazing and wonderful. But I mean, in my experience from the United States Supreme Court, and I'm actually a member of the United States Supreme Court to the 10th Circuit, to the Court of Appeals, to the Municipal Court, I have found in my experience that the courts are very good about starting with the Constitution and offering the interpretation based upon that.
Interesting.
That's what it should be. But
yeah. Well, Beth Anne, it has been a pleasure to have you on today, and I so much appreciate.
I'm sorry, I had so many technical problems.
That's the way things work. That's why you have a live podcast.
Yeah, perfect.
But you've given us a couple of things for sure that we didn't know before, and we will absolutely, those are super important. And I just appreciate so much. Michael, do you have anything before we pop off with Beth Anne?
No, that's it. That was great.
Thank you. Thank you for having me very much.
Well, thank you for what you do, and thank you for giving us, some food for thought here, because it was great stuff. So thank you so much. And it's so great to see you again. I miss
It's
you.
good to see you too, Mayor.
Talk to
Okay.
you
Yeah,
later.
take care. Thank
All right.
you. Bye-bye.
Bye-bye. So that I thought that was very interesting. And I think because I think Beth Anne is very smart and she's very sweet. And in my perspective, she has really tried to balance that, what the citizens need versus what the town needs. Because when you think about, you have to think about who an attorney is employed by.
Yeah. Yeah.
Because an attorney is going to do what their employer, they're going to have to protect their employer, whatever that looks like. And in the case of municipalities and school boards, that's people who pay their salaries.
Well, I could see, and you could kind of tell, she's much more on the side of the city and their purposes. And I can see that. And I can see protecting the actual people or employees there. But like the elected officials, the board members, the mayors, the superintendents, those people like that, in one way or another, those people need to be held to a much higher standard of accountability, of transparency, of those type, because those people do work for us. I mean, yes, there is government, there is people, but that government is there for us. It's not just its own entity that gets to separate itself from us just because they're the government, in my opinion. So I can see, yes, there's probably heavy burdens in smaller municipalities, if you've got huge record requests, but how much resource is actually dedicated away from people that actually do the services compared to filling out, whatever those requests may be.
Well, and I think in knowing Beth Anne and who she represents, she does represent smaller towns.
Yeah.
And she doesn't charge what some of the attorneys do. So for me, from my perspective, she was incredibly valuable to us because we were able to have a town attorney, and we didn't have her to protect us from the public. We were trying to, at least when I was mayor, I always wanted to make sure that we were doing what we needed to do for the public. Are we legally providing what we need to do when we have a meeting? Are we doing what we should be doing to make sure that the public is aware? And I do remember numerous times, I would say, well, Beth Anne, I don't agree with that. I mean, we need to be able to do this, and but the problem is that we have, the system is crap anymore, and bless Beth Anne's heart, she makes a living off of it, and she wouldn't say anything differently, but the system is just crap. And when I was in court the other day, listening to these two groups argue this Epic request for information from Epic. No, it's when you have 52,000 documents and you're trying to get them from I think it was, and I'm not even sure exactly what that specific thing was. I just know from sitting there and listening, they were talking about getting documents. If you have AI, you should be able to pretty easily provide a huge number of documents. But if you really do have a small town or you do have a small school district, it is really hard for them to get things out. Now, I'm not making an excuse. So hear what I'm saying. I'm not making an excuse, but what I am saying is tailor your open records requests so specifically when you're dealing with smaller entities to make it easier for them to be able to answer you. And then if they can't answer you and you've made it easy, then there's a huge problem. But you can't go to my school district, who has, I think we have maybe 600 kids in the whole entire district from K to 12. You can't go in there and ask them for 52,000 documents. I mean, it's never going to happen. They just don't have enough personnel to make that happen. I mean, same way with our town. I mean, you can't come in there and ask for 52,000 documents. Our town's not, we only have 3 employees, that are in the office. How are they going to be able to meet that request? So in one sense, you have to be cautious, but in the other sense, you have to push it to the limit, because if you've been, realistic about your goals and those goals still aren't being met, then you have to take them to the mat.
Yeah, but I find though, Jenny, kind of in these more rural areas, you have a lot more responsiveness just by talking to that mayor or that councilman or that teacher or that superintendent. Most of those issues can be solved, pretty quickly.
I would agree.
I don't know how many. It'd be interesting just to see how many large requests come into a small town. I'm sure they're more commercially based than anything. I bet you, companies want to get data in one way or another out of the school system or out of the city.
Yes.
So then just a citizen saying, hey, I mean, unless it's someone, like she said, that has an axe to grind with a certain person, and
right.
They're just wanting to expose them in any way possible. Right. But yeah, I mean, it's a sticky situation, but I still feel like a lot of these places, they use the nuances, like, right. And she said there's a lot of nuances in the Open Meetings Act and things like that. They use those nuances to their advantage to not be as forthcoming or honest or upfront with us as they should be. Because I think in a lot of these, highly contested areas where they're, it's a real hot button, they're going to go back in executive session. You don't know what they're saying. And a lot of times you don't even know they're going to go talk about that in executive session in the first place.
Well,
and
but
we've also, what I was going to ask her, we've also seen in some of these school districts where the superintendent will call each individual board member and ask if they're okay with this.
Yeah. And that's not legal.
Yeah. And take
it's not legal.
Yeah. Behind the scenes without having to tell the public.
Right.
We've seen that too. And that's something else that needs to be addressed.
Yeah. No, it's absolutely, you're absolutely 100% right on that. And Whitney Mullica from Pike Off OTA was going to be on with us today, but they've had a death in the family and she wasn't able to be here. But I did want to point out, just read what she had said about this bill. So it's HB 2730, would amend 51 of Title 51, Section 24A5, which relates to inspection and copying of public bodies and official records, which is exactly what we were talking about. As an organization that promotes responsible transportation policies in Oklahoma, we must support common sense reforms of the state's Open Records Act. In our experience dealing with state agencies such as the Oklahoma Department of Transportation, the Oklahoma Turnpike Authority, we've witnessed how long agencies are currently allowed to delay and drag out the process of fulfilling open record requests. Accountability and transparency must be maintained for the state to implement favorable infrastructure policies. The current status of Oklahoma's open records law does not have a time limit for responses to requests. This gives agencies the leeway to slow play our requests and does a disservice to the spirit of the Open Records Act. The Open Records Act was a significant step toward promoting openness and transparency in government. However, its effectiveness has been limited by loose enforcement, unrestricted time limits, and agencies chronically sidestepping the law's intents. Representative Annie Men's legislation is another positive step toward more accountability in Oklahoma's agencies and leadership. And it is, I hear what Beth Anne is saying, but maybe we do have to have like a sliding scale or something, because the OTA, for God's sakes, is a huge, huge bureaucratic, non-elected official nightmare that should have the facilities to be able to provide any kind of open records requests anybody would ask for.
Yeah.
There's absolutely, in my personal opinion, no dadgum reason why these people should slow roll the public. None.
Yeah. Well, they do, but that's what we see from all these larger, more controversial, I'll say, in one way or another. They can use that law to literally just wait years
Yep.
and years. And I'd like to see one more provision to that Open Records Act. They need to just basically, I know they in the one now, they have a set price, for like faxes or copies or this or that. They need to the legislature actually needs to come out and set a price for, this is the research price. This is the hourly, whatever price. This is, because everything's digital now. I mean, how long does it take to go grab an invoice off a computer and email it?
Well, now I will say, yeah. And I will say though, I mean, when I started in Luther, we may have been a few steps behind the dark ages even.
Yeah. Well, and I understand that. I understand that too. But what I'm saying is, you see these municipalities or organizations or school boards, they put in their own policies.
They do.
For how much they're going to charge.
Yeah.
And it's exorbitant. They're trying to, on purpose, deter parents or whoever it is, from filling out that request, because it's going to cost you hundreds and hundreds and hundreds of dollars. I mean, I remember one time I sent in a request for some emails and calendar dates at Edmond Public Schools. They literally emailed me back, said, Michael, this is going to cost $750. Is this really what you want to do? And it wasn't really that much stuff, but they made all these crazy, and how do you, and on top of that, how do you dictate how many hours it's going to take to actually do the research? I mean, they're saying, oh, it's going to take 10 hours at $125 an hour, or, this or that. I mean, it's crazy.
Yeah, that has got to be, because it's using taxpayer funds against us. So we're being charged twice. We're being charged to keep this whatever school, town, whatever open. And then we're being adjudicated against by our own tax dollars when our attorneys, the attorneys won't allow us to have, and so much of this stuff is just basic. I haven't said this publicly yet because I was going to try to put something together about it, but we lost our case at the Supreme Court. So that the city of Stillwater gets to, or I'm sorry, not the city of Stillwater, the Stillwater School Board gets to just throw people out of a public meeting for whatever reason they want. Yeah, and
pretty insane.
If they want to speak biblically or do whatever, they can just pitch them out. It's whatever they want to do. Again, a taxpayer entity pitching out a taxpayer for not doing anything, for not creating a scene, for not doing anything else other than reading scripture at the podium. And the Supreme Court denied us a hearing. They're not going to even hear it. And the Stillwater, one of the two attorneys firms that represent, gosh, wouldn't that be a great job to just get taxpayer funds from a school? You just sit back and, hey, reap the benefits of those taxpayer funds. So they charged us, how much was almost $50,000. Well, we don't know what it is since they had to answer the Supreme Court charge. So I'm going to say upwards of $50,000 in taxpayer funds to keep the school board of Stillwater from apologizing to Bryce Chaffin.
Yeah.
How do you manage to think that that's okay? So wouldn't it have been easier to save the taxpayer dollars and just say, oh gosh, Bryce, we probably never should have done that. We really apologize. So in other words, they just literally want to run over the public. That's what Stillwater wants to do. They just want to run over the public, frighten them, propose a system of tyranny, basically to keep people from standing it. We're going to throw you out if you do it. Right. So this is where we are today. This is where we are.
Well, and it's pretty amazing the Supreme Court wouldn't hear that case.
Well, considering the fact that there is actually a state law that our attorney, Maria Seidler, filed using this state law that protects religious speech. So
Yeah.
the Oklahoma State Supreme Court would not hear a case based on religious free speech that was predicated upon a law that was already created ensuring religious free speech.
Well, what I call it the other day, clown world. We're in clown world.
Well, in all honesty, I mean, it really is, because I completely disagree, unfortunately, with what Beth Anne said about case law. And, again, I know that her perspective is one, but I sat there and listened to this case yesterday where the Constitution says one thing and the case law has gone completely on the other side of it and allowed what the Constitution disallowed.
Yeah. Well, in her experience, maybe she's never really seen anything, from her experience with cases that go against the Constitution.
Well, and maybe that's true, but I mean, you really think about it, our Constitution, our state Constitution ensures free speech. I mean, just based on the state Constitution alone, we should have had the Stillwater Public Schools apologizing to Bryce Chaffin for removing him from the podium for reciting scripture. So, I mean, when there is no justice in the land, the people groan. Isn't that what the Bible says? And there is no justice in this land. And when you predicate everything on case law, and that case law was far away. So if you make a bad law and then you use that bad law to in another process, you're going to create even worse law than you started out with. It's kind of like the telephone game. Remember the telephone game?
Yeah.
You start out whispering, and then toward the end, it comes out an entirely different thing. That's what we're doing. We've gotten further and farther and further away from the Oklahoma Constitution and the United States Constitution.
Well, and it's going to set the precedent now to where if you're at some type of open meeting, whether it's school board or city council or whatever, and let's say you veer off of whatever your topic is and you quote something that they don't like, and they can just throw you out. I mean, basically is what that's going to say, is they can just throw you out.
Yeah. I don't, and I struggle to figure out how we get around that.
Yeah. It's going to be
because
tough.
We're losing attorneys to this mindset of case law is okay. I mean, that's been the case for, oh gosh, let's see, since John Marshall.
Yeah.
So 1888, 9, something like that.
Yeah.
So, I mean, when you've done well over, 100 and something years on case law, think about how far away we are from the Constitution on so many things.
Yeah.
All right. Well, it's Friday, and we probably have other things to do other than depress people with how far we are off the Constitution. So guess who's on Wednesday?
Let's see. Julianne?
Yes, you cheated.
No, I didn't cheat.
Oh, really?
No.
Good for you. Yes, Julianne will be on with us on Wednesday, and I'll text her today and find out what we're going to talk about on Wednesday. But she's always
she's
so
good.
awesome to talk to. Friday we'll have Sherry on. She'll probably talk about her legislation. We talked about a couple of things that she's going to want to talk about on Friday, and she's actually going to talk with us on Friday about why she's leaving the legislature. So that ought to be a really interesting conversation. So for those of you who are watching, make sure you tune in on Friday, because she's going to talk about that. And she still has a bill that we're following. It's over on the Senate side now, that I think will be really helpful to us, because it'll prevent teachers and school employees from contacting children independently. And Michael's gone. So I have no idea what happened there, but I will go on. So we'll have Julianne on Wednesday. We'll have Sherry on Friday. Please tune in. And if you were watching the show, please have other people check this out. I mean, we do need to know what's going on with our open records laws. It's super important. I don't think we pay quite enough attention to that, and we need to do that. So please, thank you again for being with us today. Really appreciate it, and we will see you again on Wednesday. So have a wonderful weekend, and thanks again for tuning in.